Hi, welcome back to another episode of Health Freedom with Dr. Layne. And in this video, we are going to finish up our series on the differences, the benefits between churches, ministries, and faith-based organizations, which you're going to hear, they're kind of all a faith-based organization, but there are some differences. Check out those videos previous to this ones to find out about unincorporated, incorporated churches and ministries. So what is a faith-based organization and how does it fit into the private membership association structure? A faith-based organization is a church, a ministry, or both, but it doesn't have to be either. With the proper founding, you can have an organization that is faith-based, but is not a church or a ministry. For example, I have a faith-based private health association or private membership association. It's just another title for my health association. A PMA, all your clients must be members, and this is a little bit different than the ministry or church structure. The PMA, a member to agreement. With a ministry or a church, you can go to a public event that they have or go visit the church, but you don't have to be a member. You may decide to become a member. You may decide to make greater use of their services and then become a member of that organization. With a faith-based organization, you can still have services as your payment fee or charging fee. You don't have to call them donations for your services, whereas a church or a ministry needs to have the donation structure in place. A faith-based organization isn't quite as diverse. That's totally okay. It just means that you're focusing your craft, your healing arts, your coaching, your education that isn't going to be a school in a more focused area instead of having a lot of different things going. And do remember that you do need to have a solid faith-based belief system to qualify as a faith-based organization. I mean, it just makes good sense, right? We're not trying to work the system. We are saying that since the system is out of their lane, we are moving into a new lane with a very strong divider or shield or wall around it. If you like this content, consider liking, subscribing, and sharing this channel. All right, so here's a question that everybody has is taxes. First of all, if you decide to take the PMA route and establish a faith-based organization, whether it's the church, the ministry, or a faith-based organization, something like I have, the 508c1a title that you hear talked about a lot is actually, it's a tax code. It's the IRS tax code, and that's all it is. So you don't have a 508, that's the tax code. You have a ministry or a church or a faith-based organization. So how did we get here? Well, a 508c1a faith-based organization tax exemption status stems from the First Amendment, and it's not a government subsidy. The faith-based organizations can be organized and operate under the section 508 of the tax code, the same as they can be organized and operate under any other section of the tax code. A 508c1a faith-based organization has a constitutional and legal right to form. Therefore, there's no required application for that tax exempt status. Since the 508c1as are tax exempt, they're already tax exempt. As a right, they don't have to give up that right to religious exercise and free speech as the 501c3 sneaks in. They become a creature of the state. All organizations seeking tax exempt status must apply to the IRS except for the faith-based organization. FBOs, they can be formed under this section 508 C1A and enjoy the mandatory exemptions which are already inherent in their structure as a religious organization. Section 508 was codified in the Internal Revenue Code in order to formally establish the right to free exercise of religion, which had been a standard upon America was founded and governed since it's gained its independence. So again, by the very nature of its creation, a religious nonprofit tax-exempt organization. Section 508 was part of the legislation passed in the Tax Reform Act of 1969, codified as public law. And the intent of our U.S. Congress in passing this Section 508 was to make sure that the important First Amendment religious speech rights were protected when they overhauled and authorized sweeping new changes to the tax code in 1969. And this tax act codified those substantial changes in the treatment of the 501c3s. So this is when they had to apply. They have to file the tax return annually, comply with rules and regulations that the IRS may from time to time prescribe, keep records of income and expenses, and render under oath about the organization. So they become the creature of the state. They become a public entity, not a private entity, as we are in the private membership association world or domain. If you have questions about this or anything else dealing with private membership associations, go ahead and look in the description below and you can follow the link to book a free consultation call. Thank you for being here and we'll see you next week.